Hi, Mike. It's Rachel Lippman. So I went ahead and launched that broadcast. Was just checking to see, and sent out an invite when I did so. Was just checking to see if you had seen it and what was up. Okay. I do not see you, which I know is the problem we had. I sent an email. Okay. I sent an invitation to Gmail when I started the broadcast. I don't remember if that was what we needed to do. Video call ended with an error. Okay. Right, and I was able to see you. All right. Because the problem is we've already sent out the link that this is connected to. So if we have to start this over, because it's telling me that it's live. And I still can't see you. Can you see me? Okay. Try. Okay. I'm going to send another invite to your Gmail from my Gmail. See if that helps. Just posted the invitation again. If there's anyone who's joining us for the Labor Law 101, we're working on some technical difficulties right now. Okay. Now I see you. There you are.
We'll get this.
All right. Hello. I'm going to go ahead and then hang up this phone.
Okay.
So hopefully we can hear each other from there because I can see you now. So I see you standing up and walking away.
Yep. Just hanging up my phone too.
All right. Michael, can you hear me?
Yeah, I can.
All right, and I can hear you perfectly clear. So I think the way we decided this is I will do the PowerPoint presentation from my end.
Okay.
And so I'll share the screen, and what I will do is we'll go ahead and I think give people a couple more minutes to join.
Okay.
And then just start the show.
Very good.
So for those of us who are joining us for the Illinois News Broadcasters Association webinar on Labor Law 101 with attorney Michael Lyde, we're going to give people a little bit more of a chance to join. And we will be right back with you. So hang tight.
And not that it's a big deal, Rachel, but it's Lead, not Lyde.
Lead. Sorry, my apologies.
I've had to contend with it all my life.
Okay. All right. Give people about another minute or two.
No problem.
And this just totally slipped my mind. Lead?
Yeah, Lead.
Last name Lead. Okay. I'm going to write that down because otherwise I'll forget it. All right. Let's go ahead and get this started. Welcome to those of you who are joining us for the Illinois News Broadcasters Association's webinar on Labor Law 101. Joining us today as our expert is Michael Lead. He's a labor attorney with Howard & Howard in Peoria, Illinois. And because I know all of us are pretty busy as journalists and probably working on a story as we speak, I'm just going to go ahead and turn it over to Michael, and we're going to go ahead and get started. So he's got a PowerPoint presentation for us. I'm going to go ahead and bring that up and share the screen with everyone. Oops. 1 second, we'll make this work. Bring up the PowerPoint there. Go back to here. Share the screen. Come on, guys. All right. Everyone should be able to see my screen now. I've shared it with you guys. So I'm going to present that to everyone. All right. Michael, the floor is yours.
Great. By way of background, come this summer, I will have practiced labor and employment and immigration law for 33 years. We've seen something that is worth noting, that particularly with the agency that we're going to be talking about today, it is very much a creature of who's in the White House. And the Obama Labor Board has changed a number of areas of law, in some cases overturning as much as 50-year-old precedent. So there certainly are always a lot of interesting developments in this area. Do you need me to advance the slides, or are you able to?
I think I have to do it because it's on my screen. So, so Michael, you should be able to see. Can you see my slideshow?
Yes, I can.
All right. So I'll kind of take the cue from you as to when we need to advance it. The floor is yours.
If we go to screen 1.
Okay, this intro screen or this one?
The next one.
Which one? This one that says applicable law?
Correct.
Okay. All right, there you go.
Thank you. The heart of the National Labor Relations Act, also sometimes called the Labor Management Relations Act, is Section 7. And what it does is grants employees, as you can see, the right of self-organization to form, join, or assist labor organizations to bargain collectively through representatives of their own choosing and to engage in other concerted activities. Now, even non-union employees have rights under Section 7, and that's been one of the big developments with the Obama Labor Board, is what I would call a very activist labor board that inserts itself into situations where there is no union. Next slide, please.
Should be there for you.
If we can go to the next one, please.
The one that says employees have the right to refrain from?
Right.
Okay, it should be there.
This is a corollary to the right to organize and to engage in collective activities. The same Section 7 also gives employees the right to refrain from such activities to the extent that there is no labor agreement that requires membership as a condition of employment. And most collective bargaining agreements I've ever seen do, in fact, require employees to become members within a certain amount of time, typically 30 days of hire. Next screen, please.
There we go. Come on.
Not everyone is covered by the National Labor Relations Act, and as you can see, excluded from coverage and therefore protection are supervisors, certain agricultural and domestic employees, persons that are employed by their own parent or spouse, and true independent contractors. Who is an independent contractor is also a very hot issue these days in a lot of different areas. Next slide, please.
There you go.
And again, generally, the National Labor Relations Act covers private employers, so federal and state governmental agencies are not governed by this statute, but labor organizations are covered when they act as an employer, and as we'll see when we discuss unfair labor practices, there are certain regulations of unions in this statute as well. Next slide. The National Labor Relations Board is the entity that deals with the National Labor Relations Act, and it has primarily two functions. One is to conduct elections in a variety of situations. We'll get into various types of those. And it also investigates and prosecutes unfair labor practice charges. So it has two primary duties. One is to conduct elections and then certify the results, and then secondly, to deal with unfair labor practice charges. For the most part, the NLRB conducts elections when employees file generally information showing that at least 30% of employees are interested in having a union. The employer in some cases can voluntarily recognize the union, and unions sometimes can present union authorization cards to the employer, and if the employer looks at them and is satisfied that a majority of the employees want a union, an election may be unnecessary. One recent development is that the National Labor Relations Board has decided that in some cases unions can tender union authorization cards with electronic signatures rather than pen and ink signatures. As the slide indicates, when a union is elected, it becomes the exclusive representative of all employees, even those who may have voted no in the election. And after that, the employer has to deal with the union, but may no longer deal directly with its employees. So one of the things that happens here is when a union is elected, the employer now needs to deal with the third party with regard to wages, hours, and conditions of employment. Next slide, please. As I mentioned, there are a variety of types of elections. One is to certify the union. In some cases, the employer has competing unions that are interested in representing its employees, and in that case, there may be an election to decide which of the two unions the employees really want. There may be an election in some circumstances to decertify the union, and what that means is that the union is voted out. And there may also be a deauthorization election, which basically has the purpose of getting rid of a union security clause in a collective bargaining agreement. What that means is if the union is decertified, it continues to represent the employees, but employees do not have to join the union. Next slide, please. A unit clarification election typically is one that is authorized in order to determine if additional groups of employees should be covered by the union's representation. And in some cases, there can be an election to amend the certification of the union as a bargaining representative. So there are a series of different types of elections. They have different designations for purposes of the National Labor Relations Board. And in most cases, particularly decertification and elections like that, they can only be filed at certain points in time, and the employer is not entitled to file those types of election petitions. It has to be done by the employees themselves. Next slide, please. There are, again, some rules on the elections. There's a 12-month election rule. What that signifies, to give you an example, is let's say there was an election, the union lost that election. For 12 months, it may not seek to have another election. So the employer has a year where it's free of union election petitions. Likewise, when the union is certified, it is entitled to be secure, let's say, that it's not going to be challenged by a decertification election for a period of 12 months. That's called the certification bar. The contract bar doctrine says that generally during the term of a contract, a decertification petition cannot be filed, and a rival union cannot file a petition either. Normally, that's contract bar lasts for a maximum period of 3 years. An unfair labor practice blocking charge is one that unions often file tactically if they get wind of the fact that employees may be contemplating filing a decertification petition. The union may file an unfair labor practice charge, and as a matter of board policy, it normally does not hold the election until that unfair labor practice is dealt with in some fashion. Next slide, please. One issue that comes up a lot is what is the appropriate bargaining unit, and one of the changes that was made a couple of years ago is as a result of an NLRB decision, we can have very tiny bargaining units, and that will still be found appropriate. From the employer's point of view, it normally wants what's called a wall-to-wall election, in other words, covering all of its employees by the simple logic that it's harder to get a majority of, let's say, 400 employees than it would be to get a majority of 15 or 20 employees. An appropriate bargaining unit typically will exclude supervisors, professionals, guards, and certain confidential employees, typically assistants to the human resources manager and people like that. So an appropriate bargaining unit is anymore one that is chosen by the union made based on its calculus of its likelihood of winning the election. And it's the employer's burden, and it's become a very high burden to challenge that bargaining unit that the union wants. Next slide, please. One of the things that employers and unions always have to deal with is strikes. And the Labor Management Relations Act preserves the employee's right to strike over wages, hours, working conditions, and unfair labor practices. It's a big gamble for the union to go on strike because, as you see, economic strikers can be permanently replaced, but unfair labor practice strikers may not be. So the characterization of the dispute leading to the picketing or the strike is pretty critical on employees' rights to preserve their jobs. Now, I put permanently in quotes, and essentially what that means is the employer is entitled to hire replacement workers, and if the union makes an unconditional offer to return to work, as there is employee turnover, it may have an obligation, even in an economic strike, to rehire some of the former striking employees. But oftentimes, permanent really does mean permanent. The employer hires replacements, and if there's not that turnover, those employees may never be reinstated. As we point out at the bottom of the slide, employees who quit in good faith because of abnormally dangerous conditions are not considered to be on strike. Next slide, please. The law makes a distinction between primary and secondary strikes, and the primary employer is the employer with whom the union really has the dispute. But as probably most of the listeners know, sometimes other entities get involved in a labor dispute as well. For example, let's assume we've got a shopping mall and a store is being remodeled by non-union employees. The union is certainly entitled to picket and to strike to challenge that particular store's use of non-union labor, but it's not at all uncommon that the landlord or other stores get enmeshed in the picketing and other activity, and that would be secondary activity, some of which is okay, but much of which is unlawful. As we see on the slide, the law prohibits the union from picketing to force or require an employer to join any particular labor or employer organization, to force or require a person to quit dealing with another person. That's the classic secondary action, or to force or require an employer to recognize or bargain with a particular union if another union has already been certified. Next slide, please. It's also illegal for a union to strike to force or require an employer to assign work to one union rather than another. And that's called a jurisdictional dispute. And particularly in construction, there are often disputes between different trade organizations as to who should do what work. Next slide, please. Sympathy strike is one where employees go on strike in sympathy with another union. We often saw that with the Teamsters, who might refuse to cross a picket line established by another union. That's a type of sympathy strike. Consumer boycott or leafleting is different than picketing, and generally unions have greater latitude to encourage a boycott of a particular business or to hand out leaflets encouraging consumers or shoppers to boycott a particular store or business. In picketing, we almost always have private property issues. Public property is almost always fair game for picketing, but it's oftentimes disputed as to whether or not a union's entitled to be on private property as opposed to being on a sidewalk or at the edge of the street. And in one of the areas where state courts actually have some jurisdiction is picketing or strikes which cause a breach of the peace. And in some unusual circumstances, a state court may enter an injunction either stopping activity which is dangerous or poses the risk of a breach of the peace. But the National Labor Relations Board may have jurisdiction as well. Next slide as well. As I mentioned, A second function for the National Labor Relations Board is to investigate and prosecute unfair labor practices. There are a series of things that are illegal for employers to do. And again, these are sections of the National Labor Relations Act. Section 8A1 prohibits an employer from interfering, restraining, or coercing employees in the exercise of their Section 7 rights. 8A2 prohibits an employer for dominating or interfering with the formation or administration of a labor organization or to contribute money or other support to it. Next slide, please. A common allegation is an 8A3 violation in which the employer is alleged to discriminate in either the hire, discharge, or some other term or condition of employment to either encourage or discourage membership in any labor organization. And this often comes up, let's say that there's organizing activity and the employer figures out who's the ringleader and decides to terminate the ringleader. If that is done for that reason, that would violate Section 8A3 and derivatively violate Section 8A1. Less common would be an 8A4 violation, which involves discrimination or discharge of an employee because he's filed charges or given testimony. 8A5 violations do come up rather often when the employer is alleged to have failed to bargain in good faith, and that can come up in situations such as the employer doesn't bring to the bargaining table people with authority to actually make an agreement, refusing to provide information that the union needs to carry out its duties as a bargaining agent, unnecessary delays or canceling meetings and the like. Those are all examples of what might be an 8A5 violation. Next slide, please. As I mentioned, the union can also commit unfair labor practices. 8B1 involves restraining or coercing employees in the exercise of their Section 7 rights. Although, as the slide points out, the union may establish rules regarding acquiring and maintaining membership, and most unions do in fact have bylaws and constitutions that regulate the behavior of their members. 8B2 would be a union violation which causes or attempts to cause an employer to discriminate against an employee if union membership has been denied or terminated except for the employee's failure to tender dues or fees. So this would be if a union refused to grant membership out of some desire to, again, have a union activist, you might say, that maybe disagrees with what the union as a whole wants to do. Next slide, please. A corollary to the 8A5 violation is an 8B3 violation where the employer alleges the union has failed to bargain in good faith. 8B4 is a section of the law that regulates certain types of strikes or picketing, typically secondary boycotts or secondary activities. 8B5 prohibits the union from requiring excessive membership fees, and 8B6 is called feather bedding. That's attempting to cause the employer to pay for services not actually performed by the employees. Next slide, please. And then finally, 8B7 prohibits the union from picketing an employer to force recognition of the union except as otherwise permitted by law. Next slide, please. And either a union or an employer may commit an unfair labor practice if they enter into an agreement in which the employer ceases or agrees to cease handling, using, selling, transporting, or otherwise dealing with the products of any other employer. That's called a hot goods provision. And again, it's unlawful for either the employer or the union to enter into such an agreement. Next slide. As we've already indicated, the Labor Management Relations Act is enforced primarily by the National Labor Relations Board. And mechanically, how this happens is in the election situation, in some cases, the only way that the employer can get a review of a decision certifying a union is to refuse to bargain with the union, and then the National Labor Relations has to National Labor Relations Board has to bring enforcement action. And again, the standard is very high, but in order to challenge the outcome of the election, the employer may have to refuse to bargain. In an unfair labor practice case, by comparison, if the case is found to have merit, the regional director, and our region is main office is in Chicago. There's a sub-region in Peoria here, and there is another region in St. Louis. Those regional directors evaluate unfair labor practice charges and decide whether or not they have enough merit to go forward. If so, a lawyer, as a member of the Office of the General Counsel of the National Labor Relations Board, files a complaint. The employer files an answer or may file some procedural motions. If the matter isn't resolved otherwise, it goes to a hearing before an administrative law judge. And the administrative law judge is the primary finder of the facts. If you were to read some of the decisions, oftentimes they are very long. They can easily run 30, 40, 50 pages in a case where a lot of witnesses have testified and a lot of evidence has been taken. Whoever is unhappy with the decision of the administrative law judge can appeal it to the National Labor Relations Board, which is a 5-member board which is appointed by the president. At the moment, we have 3 Democrat appointees and 2 Republican appointees. And the decisions are often made by a 3-member panel, and as you might expect, the outcome can be different if you have the 3 Democratic appointees deciding the case, or even 2 Democratic appointees and 1 Republican, as opposed to the 2 Republicans and 1 Democrat. And we do have 2-to-1 decisions every so often, depending on the composition of the panel that hears the case. And as the slide points out, decisions can be appealed to the federal courts, and generally speaking, what that means, let's assume it's a case in Illinois, the appeal can be taken to the 7th Circuit Court of Appeals in Chicago or the District of Columbia Court of Appeals in Washington, D.C. So generally, the party that's challenging the NLRB decision either files in the Court of Appeals in the state where the case exists, or in the D.C. Circuit Court of Appeals. In unusual cases, the whole 5-member NLRB will decide a case, but again, the decision again goes to a Court of Appeals. To give you one recent example, we have had a number of decisions now by the National Labor Relations Board saying that employer policies that require employees to arbitrate disputes violate the employee's Section 7 rights, and also employer policies that require employees to waive the right to file a class action claim also violate the National Labor Relations Act. Now, interestingly, the 5th Circuit Court of Appeals down in Texas has refused to enforce those decisions, but the National Labor Relations Board basically has a policy of what I refer to as non-acquiescence. And what that means is they are simply ignoring the 5th Circuit decision, even though it is a court right below the United States Supreme Court. And they continue to hold unlawful policies that require arbitration rather than filing a charge, or policies requiring employees to waive the right to file class actions. So unlike a lot of agencies, this is one that makes up its mind and doesn't really much care if the Court of Appeals disagrees with it. It will follow that Court of Appeals decision, perhaps in that circuit, but not in other circuits. And the only way that things can really change is if the U.S. Supreme Court takes a case and decides that the NLRB is simply wrong. Next slide. This particular program is sometimes used for training supervisors, and so we've got some supervisor do's and don'ts. The employer generally has the right, and the supervisors have the right, to engage in free speech. And what that means is they can make predictions of how having a union may affect the workplace, whether it's a good idea, talk about their own experiences, if they've been in unions themselves, and so forth. Despite the National Labor Relations Act, supervisors retain the right to supervise, direct work, and impose discipline, so long as it's not for the wrong reasons. And that's where the challenges often come in. And as you might imagine, particularly in the case of an organizing drive or an employee that's advocating for rights, what exactly the supervisor's reason was may be hotly disputed, and that's where the administrative law judge's decisions is going to try to make the call as to whether the employer acted for a permissible reason or for an unlawful reason. Next slide, please. There are things that the employer cannot do, and the shorthand acronym is TIPS. The employer may not threaten, interrogate, promise, or engage in surveillance. The threat, the classic case is, if you vote in a union, we will close this business, or we will move it to someplace less hospitable toward unions. Both of those types of activities would be clearly unlawful. Interrogation is, again, sort of a gray area. What is prohibited is interrogating employees either to find out what their sympathies are toward a union or collective action, or to try to find out what's going on. And it's a classic case when the supervisor calls in an employee and says, something's going on here in the workplace, can you tell me what it is? And the National Labor Relations Board has often found that to be unlawful interrogation. And it can be interrogation even if it's a rather friendly conversation. The employer may not make promises such as, if you vote no, we will establish our own internal grievance procedure, or everyone will get a ham, or something like that. Those types of promises are unlawful. And surveillance is just what it sounds like. The employer either spies on or listens in on activities in the workplace, or sometimes gets wind of the fact that there's going to be a meeting of employees, say at a local restaurant, and the supervisor hangs out at the restaurant to find out who's there and tries to figure out what's going on. Sometimes the surveillance can even be the parking lot, looking at driver's licenses to figure out, who is there by knowing what employee license numbers there are. I don't know if there is a next slide. I don't think there is.
Nope.
I'm happy to take a few comments. Otherwise, I can keep talking a bit as well.
Mike, I know a question that I have is, are there some issues that kind of keep coming up again that would be good for reporters to sort of know a little bit about? Is there sort of like a common allegation that gets made a lot against companies or against a union where, it's sort of kind of good to know the ins and outs of that? And are there any sort of alleged violations that are less common?
Well, I would certainly say that's probably, both of those things are true. One thing that's been a very hot topic for the last 2 or 3 years at least is the NLRB taking a keen interest in employer policies. And the state of the law at this point, I think, is very muddy. And if your listeners are interested, if you were to get on the NLRB website, there are at least 3 memos issued by the General Counsel or the Acting General Counsel a couple of years ago that deal with a variety of contexts of employer policies, and oftentimes they are in the context of a non-union workplace, and somebody files a charge and says the employer has a policy, let's say, that prohibits me from discussing my pay with other employees. That's actually nothing particularly new. That's been an unlawful policy for a long time. But what started to happen is the NLRB taking interest in other policies, such as confidentiality policies, where the employer, in its policy handbook, prohibits employees from talking about certain topics deemed to be confidential. And probably what's safe is, for example, employer financial data, customer data, that sort of thing. And as you start getting into things that are more of interest to employees, like pay, like working conditions, that sort of a policy may be, well, it has been found unlawful in a number of cases. Another area that the NLRB has taken an interest in are policies that deal with social media, whether or not employees are entitled to go on Facebook and talk about the employer, on Glassdoor, Twitter, and the like, and, for example, complain about a supervisor, complain about the company being an unfair place to work, so on and so forth. And the NLRB has taken a keen interest in that. We had a decision, I believe, last year in which the Labor Board again reversed some earlier precedent and decided that at least under some circumstances, employees are entitled to use the employer's email system to engage in organizing activity. So there continue to be developments. The NLRB weekly releases its most recent decisions, and if somebody is looking for a story, that's a very easy way to see what's happening. There are always issues and a lot of cases being decided. You know, the NLRB, I think, has just stepped finally into the 20th century and has started to figure out that electronics are the way of the future. If you look on the website, you can download an NLRB app. The NLRB on its website, again, has information for employees to permit them to exercise their various rights under the National Labor Relations Act. So there's very much more of an outreach function than we have seen in the past.
You said at the beginning that the NLRB is sort of a creation of who's ever in the White House. How easy or difficult is it to kind of see a shift in NLRB decisions when someone else takes over the White House? Like after 8 years of George W. Bush, who was a Republican, how long did it take for it to shift under the Obama administration? And was that sort of typical, or does it usually take more or less time for the NLRB to kind of shift its interpretation?
I think we started to see the shift fairly fast, but what caught the Obama administration is that for a while we had only 3 members, live members of the National Labor Relations Board, and you may know that decisions of that 3-member board were challenged, and the case ultimately went up to the United States Supreme Court, which decided that the board did not have the power to act when it only had 3 members. In fact, later on, the Supreme Court also found that the appointment of the general counsel was improper as well. But what we've seen happening since that Supreme Court case is most of those decisions of the 3-member panels have been reaffirmed by a properly constituted 5-member panel of the NLRB. But I think what happens is you see those shifts fairly fast, and I'm talking a matter of a number of months when a new board starts putting its stamp and interpretation of the law on the books.
And is it immediately that they are appointed when a new president comes in, or is it just as it's an attrition as terms expire, they will appoint someone more friendly to their views?
Yeah, I'm not any sort of an expert on the appointment process, but yeah, I think that that's exactly right. The president has the power to appoint, and generally the names are floating around for a while, and there may be some lobbying done by business groups, labor organizations, and the like, but the president generally has the power to decide who he wants on the board, and you know the people that are the Democratic appointees have fairly strong union backgrounds at this point, so their outlook and proclivities are pretty well known.
Mike, are there any big cases that people within sort of Region 7 should be keeping an eye on that you think will have impacts not just in this workplace, but sort of look in a new sort of policy direction for the NLRB that could impact, have a more broad sort of precedential impact?
Well, I don't know about necessarily here in Illinois, but one of the big developments in recent years, both with the National Labor Relations Board and elsewhere, is the concept of joint employment. And you may be aware of the NLRB's position that the McDonald's Corporation, as in the restaurant corporation, is a joint employer with its restaurants or its franchisees. And that's a big deal. And the NLRB has filed a consolidated complaint involving, I believe, 8 different regions of the country. And I think it's pending in Cincinnati, if I remember right. But that's going to be big news, certainly shaking up the franchise world a bit. And this stems from a decision that changed the idea of what exactly is joint employment. And normally the law for many, many, many years had been if the other employer actually exercised some control over wages and hours of working conditions of a different employer's employees. And what the decision held is that so long as the supposed joint employer has the potential to exercise control, that's enough to find joint employment. And that's a battle that's going to be fought. In the McDonald's case, the decision that started this was one called Browning-Ferris, and that, I believe, is up on appeal as well. So that's a very serious issue in the temporary staffing world. As I mentioned, the franchising world, potentially it could be just about anywhere. Our firm is involved in a situation where the allegation is that a company that owns a variety of hospitals is a joint employer with the employees of the various hospitals. So that's big news, and it's far from settled, and it's far from settled whether the National Labor Relations Board's new view is the appropriate one or not. And I would predict that one will eventually end up in the Supreme Court.
How much difference does like state policy make? I know there's a lot of states that do right to work. There's been a big fight in Illinois with right to work. What's the interplay between sort of state policies like right to work and then what the Labor Management Relations Act says?
Well, right to work laws basically have the effect of not requiring employees to join a union, preserving their right. It overlaps, as you've appropriately figured out, with the National Labor Relations Act, but the National Labor Relations Board really doesn't have a whole lot to do with those state policies. I think the last time I checked, we've got 23 states that are right to work states, but the National Labor Relations Act is still in the picture. And, let's say even a non-union employee that feels that he or she has been discharged for reasons that violate the National Labor Relations Act would still have the right to file an unfair labor practice charge and have that decided. I didn't really talk about this, but a lot of the employment laws that we deal with, at the end of the day, the employee may not be reinstated. That is not the case with the National Labor Relations Act. That is one of the statutes where the outcome oftentimes is back pay for the time that the employee has been off work, interest that runs daily. There have been some cases more recently where, in the right case, the National Labor Relations Board may even impose attorney fees on the violator of the National Labor Relations Act and reinstatement to a job. So I have literally had cases that were litigated for almost 10 years, and you're looking at 10 years worth of back pay plus interest plus reinstating an employee. So it's a statute that has a good deal of power. It's not a very fast one, but it has a good deal of power. And one thing that has changed recently is what are called the ambush election rules by the employer community. And the basic idea is to eliminate as much as possible the employer's ability to delay having an election. And what we are seeing is sometimes as short as a period of 3 to 4 weeks between the filing of a union election petition and the actual election. And if the employer is not paying attention, it has a lot less time to get out its own message of what it really means to be a union organized place, what it means to have to join a union if they are in a non-union or a non-right to work state, the fact that the union itself can impose discipline on members and the like. And so union elections are happening much more quickly, and unions are being a little more successful, again, I think because they're catching some employers off guard, and the union gets its message out long before it files its union petition, and the employer oftentimes is caught with very little time to react and to get out its own message.
And Mike, are these sort of timelines and union petitions available on the NLRB website, or is this just something that someone's going to have to be sort of tuned in to know that they're looking to have a union election?
Well, you can get on the NLRB website and look up specific cases and oftentimes see at what stage they are. The guidance basically is a matter of regulations that can be found on the NLRB website as well. I didn't look before I talked about this to tell you exactly where to look, but I believe that there's a click button that you can look for news. You can look up cases going back years and years and years and years and years. I don't know, but I would imagine that almost every NLRB decision back to the 1930s is probably online at this point. Looking under the general counsel memos oftentimes gives you an idea of what the general counsel of the National Labor Relations Board thinks is important or thinks is appropriate policy, and get some ideas there. There are other ways, I suppose, to find that out. Bureau of National Affairs publishes NLRB decisions. A lot of law firms publish newsletters, as does ours, or post things on our website. There's a service called Lexology, which primarily aggregates law firm newsletters, and you can get on the list for the labor and employment law, and it's almost silly sometimes when there's some new development. You'll see 20 different law firms writing about it, but might also, provide a source of information. Oftentimes I'll get ideas for articles by looking at Lexology and go read a case and give my own take on it. So those are some good sources. All this stuff is available on Westlaw and Lexis as well. But
right.
The NLRB website's free.
There you go. All right, I don't see any questions. Let me quickly check again, make sure that we've answered the questions that everyone has. Mike, do you have any kind of last thoughts, any trends, any sort of tips, hints to people who may want to use NLRB or labor law as a place to go looking for stories?
Well, I would say, the cases are always interesting. It deals with human beings and work, and it's easy and fairly fast to just get on the NLRB website perhaps once a week and just see what cases they've decided. Every so often there will be a blockbuster. Sometimes it's more mundane, but the cases still are kind of interesting because, again, they deal with what people do at work, and more often now what people do in the non-union workplace. And my personal take on all this is union membership in the private sector is down to a little over 6%. And I think a few years ago, particularly with the Obama board, this was an agency that was starting to find itself becoming a little bit irrelevant. And I think the light went on with somebody and they said, non-union employees have rights under the statute as well. We will do more of an outreach to let people know what their rights are, and we will more aggressively police non-union workplaces and decide those cases as well.
All right. That was Michael Lead, the labor attorney with Howard & Howard in Peoria, Illinois. If you are interested in more educational opportunities like this from the Illinois News Broadcasters Association, you can always join us. It is $35 a month. You can get a discounted rate if your newsroom joins. You can find more information at www.inba.net. Michael Lead with Howard & Howard, thank you very much for your time this afternoon.
Thank you for having me.